He's in swim trunks, burger in one hand, Bluetooth speaker pumping some summer jams in the other. Just chilling, you know. Then, out of nowhere, two officers materialize, grab him, slam him on his own patio, and slap on the cuffs. It's a scene ripped straight from a nightmare. But for Jordan McRae, it was his Sunday afternoon. That moment, that shocking, unjust moment, ended up costing the city of Fayetteville exactly $100,000. And here's the kicker. It all started with a 911 call that absolutely, positively, never should have been made. The setup. Picture this. It's June 18th, 2022, Juneteenth weekend in Fayetteville, North Carolina. The air is thick with the promise of summer, the smell of barbecue, and the vibrant energy of celebration. For 31-year-old Jordan McRae, this weekend carried extra significance. An Air Force veteran, a proud father of two, Jordan had just closed on his first house a mere 2 weeks prior. This wasn't just a house, it was a home, a foundation he'd built for his family, a tangible piece of the American dream he'd worked so hard for. To mark this incredible milestone and honor the spirit of Juneteenth, Jordan decided to throw what he affectionately called a housewarming/Juneteenth pool party. And let me tell you, it was epic. The guest list was a mix of cherished family members, new neighbors from his quiet suburban cul-de-sac, and old friends who'd come to celebrate. Ribs smoked low and slow on the grill, dominoes clacked on a picnic table, and kids, fueled by sugary drinks and pure joy, engaged in spirited water gun fights. It was that classic cookout energy, the kind that makes you feel warm from the inside out, a tapestry of laughter and connection. Jordan, ever the thoughtful host, even hired a local teen to man the grill so everyone, himself included, could truly relax and soak in the good vibes. By 4 p.m., the party was in full swing. The playlist, curated by Jordan himself, was on point, a perfect blend of old-school R&B and contemporary hits that had everyone tapping their feet. Kids were doing cannonballs into the sparkling blue water, shrieking with delight as splashes reached the adults lounging poolside. Jordan's mom, beaming with pride, was recording a Facebook Live video, bragging to her online community about her son's beautiful new place and the wonderful life he was building. It was, by all accounts, just a normal, beautiful Sunday in the suburbs. A scene of pure, unadulterated American joy. What could possibly go wrong? The call. That's where our story takes a sharp, unsettling turn. At precisely 4:47 p.m., the idyllic scene was unknowingly shattered by a single phone call. A woman driving past the cul-de-sac decided to dial 911. "What's your emergency?" The operator's voice crackled through the line. "They're the Loud Party," the caller stated, her voice laced with a strange mix of annoyance and something else, something less definable. "And I think one of them has a gun." And then, just like that, she hung up. Before dispatch could ask for clarifying details, before they could inquire about which house, who she saw, what made her think someone had a gun, she was gone. A crucial, perhaps even malicious, omission. She gave the street name, but no house number. Not a single one. Think about that for a second. An anonymous, unsubstantiated tip, based on a vague "I think," with no specific location. Most folks would assume that's not enough to send a squad car, right? Yet, within 5 short minutes, Officer Daniels and Officer Hicks were on the scene. No warrant, no prior noise complaints from neighbors, no description of an actual, credible threat. Just a hunch, a vague fear, and a street name. And where did they go? Straight to the only house on the block with black folks enjoying themselves outside. It almost makes you wonder if they were looking for a problem, rather than responding to one. The encounter. The body cam timestamp reads 4:53 p.m., just 6 minutes after that flimsy 911 call. Jordan, ever the gracious host, spots the uniforms approaching his property. He's confused, a little surprised, but certainly not alarmed. He waves a friendly greeting, and out of respect, immediately turns the music down, signaling his cooperation. He assumes it's a quick check-in, maybe a friendly request to lower the volume a bit more. He couldn't have been more wrong. Officer Daniels, without so much as a polite introduction or explanation, gets straight to it. "We got a report of a weapon." Who's the homeowner? His tone isn't questioning, it's accusatory. Jordan, still calm, still try to be helpful, responds, "That's me. And there's no weapon here, man. Just a pool party." He gestures around, a clear invitation for them to see for themselves the innocent scene unfolding. Kids splashing, adults laughing, food cooking. Nothing menacing, nothing out of place. But Daniels isn't interested in seeing. He's interested in searching. "We need to look around," he states, his voice firm, his eyes scanning the property, bypassing Jordan's reasonable explanation. This is the moment. This is where Jordan, a homeowner, a veteran, a citizen, asserts his rights. Calmly, clearly, he replies, "I don't consent to a search. You're on my property without a warrant." He knows his rights. He knows they can't just waltz in. And this, my friends, is a classic audit-the-audit moment, a textbook example of what happens when a citizen stands firm on their constitutional protections. The second Jordan utters those two powerful words, "no consent," everything changes. Officer Daniels' demeanor hardens. Without another word, without a warning, he lunges forward and grabs Jordan's wrist. "Yo, what are you doing?" Jordan exclaims, his calm shattered, replaced by shock and disbelief. The festive atmosphere instantly evaporates, replaced by a chilling tension. Within 12 agonizing seconds, think about how fast that is. Jordan McRae, in his own backyard, at his own party, is face down on his patio, a heavy knee pressed into his back, handcuffs biting into his wrists. The party guests, who moments before were enjoying a carefree afternoon, are now stunned witnesses. Their phones, which had been recording joyous family memories, are now pointed at the unfolding horror, capturing every brutal, confusing second. Children, who had been laughing and playing, are now crying, their innocent eyes wide with terror and confusion. Jordan's mom, still live-streaming her proud moment, unwittingly becomes a live documentarian of her son's humiliation. 3,000 viewers from all corners of the internet watched in real time as a peaceful celebration devolved into an unlawful arrest. The cheers turned to gasps, the music to cries, and a summer day to a nightmare. Section 4 lockup. The officers, having violently subdued a man who was simply asserting his constitutional rights, then proceeded to charge him with obstruction and resisting arrest. Of course, no weapon was ever found. Because there was no weapon, it was a fabrication, a phantom threat conjured by a biased mind and acted upon by officers who failed to do their basic due diligence. Jordan, the proud homeowner, the loving father, spent that night not in his new bed, but in the cold, unforgiving confines of the Cumberland County Jail. Can you imagine the indignity, the fear, the crushing weight of injustice, and the bitter cherry on top? He missed his daughter's kindergarten graduation Monday morning, a milestone, a memory he'll never get back, stolen from him by an unlawful arrest. While Jordan was locked away, the world outside was reacting. The viral clip of his arrest, raw and unfiltered, quickly spread across social media. It was already being titled, heartbreakingly but accurately, "Arrested for being black at a pool party." By Tuesday, local news outlets had picked up the story, the outrage growing, the injustice undeniable. The McRae family's private nightmare was now a very public spectacle, a glaring spotlight on a systemic issue. The decision to fight. When Jordan finally got out, the anger and humiliation were palpable, but so was a fierce resolve. He wasn't going to let this stand. He didn't want to just move on and forget. He wanted justice. He needed to fight, not just for himself, but for what was right. So, he did what many in his situation do. He sought legal counsel. He hired attorney Keisha Williams, a formidable force from a civil rights boutique firm in Durham, known for her tenacity and unwavering commitment to her clients. In the consultation room, the air was thick with purpose. Keisha, her gaze sharp and intelligent, laid out the legal landscape. They had zero probable cause, she stated, cutting straight to the heart of the matter. Zero. This was a clear violation of your Fourth Amendment rights against unlawful search and seizure, and your 14th Amendment rights to equal protection under the law. We sue on 4th and 14th Amendment violations. Jordan, still reeling from the experience, looked at her, his voice steady despite the trauma. "I don't want a quick settlement," he told her, his eyes burning with conviction. "I want my name cleared, and I want the city to feel it. I want them to understand the cost of what they did." He wasn't just looking for compensation. He was looking for accountability, for message to be sent loud and clear. Keisha Williams, a veteran of countless battles against injustice, simply grinned, a slow, knowing smile that spoke volumes. "Let's make it hurt," she affirmed, a shared understanding passing between them. And hurt it would. They filed a lawsuit in federal court, alleging unlawful arrest, excessive force, malicious prosecution, and racial discrimination under the powerful Civil Rights Act, specifically 42 U.S.C. Section 1983. This isn't just about a bad day at the pool. It's about fundamental constitutional rights, about the state's power, and where it oversteps. Section 1983 is the legal hammer used to hold government actors, including police officers, accountable for depriving individuals of their rights. It's a serious claim, and Keisha Williams was ready to wield it. Discovery gold. This is where the layers started peeling back, revealing the truly ugly truth beneath. The discovery phase of the lawsuit is like a legal treasure hunt, and Keisha Williams struck gold. Depositions, those sworn out-of-court testimonies, brought some astonishing revelations to light. First, the 911 caller. Remember her? The one who made the vague, unsubstantiated claim? Well, it turns out she was the ex-girlfriend of Jordan's next-door neighbor. Let that sink in. An ex-girlfriend. She admitted, under oath, that she had never even met Jordan. Her reason for calling 911 for alleging a gun? She assumed someone black at a loud party must have a gun. Not saw, not knew, but assumed. This wasn't about public safety. It was about prejudice, pure and simple, possibly fueled by some lingering neighborly animosity. What a chilling insight into the insidious nature of implicit bias and outright racism. But it got worse, much worse. It was revealed that officers had actually run Jordan's license plate earlier that very week during a routine patrol. And what did their internal notes say? New homeowner, keep an eye. Let's be frank. In a predominantly white neighborhood, when a black family moves in, and then police notes say keep an eye, it's hard to interpret that as anything other than racial profiling. It suggests Jordan was flagged, not for any wrongdoing, but simply for his presence. And then there was Officer Daniels. His internal affairs file, which Keisha meticulously dug up, painted a disturbing picture. 8 prior complaints for unconstitutional stops. Not 1 or 2, but 8. The city had settled 3 of those complaints, conveniently sealing the records. This wasn't an isolated incident. It was a pattern of behavior that was clearly tolerated, even enabled, by the very system meant to protect citizens. Keisha Williams, with her keen legal mind, summed it all up perfectly in her brief. Pattern meets prejudice. It wasn't just a bad call or a single rogue officer. It was a confluence of systemic issues, racial bias, a lack of accountability for problematic officers, and a disregard for fundamental constitutional rights. This wasn't just Jordan's story. It was a microcosm of a much larger, deeply entrenched problem. Courtroom drama. The case proceeded to a bench trial, meaning a judge, not a jury, would decide the outcome. Judge Sarah Linden, known for her meticulous attention to detail and unwavering commitment to justice, presided over the proceedings. The courtroom, usually a place of solemnity, crackled with tension. The city attorney, representing the police department, tried to argue exigent circumstances. They claimed that because of the gun mentioned in the 911 call, the officers had an immediate and compelling reason to act, bypassing the need for a warrant or further investigation. They painted a picture of officers bravely responding to a potentially dangerous situation. It was a desperate attempt to justify the unjustifiable. But Keisha Williams was ready. She didn't just present evidence. She performed a masterclass in legal dismantling. She played the body cam footage, frame by excruciating frame. She showed the court the music volume, 68 decibels, perfectly legal under city ordinance. Not an ear-splitting, disruptive roar that would necessitate an emergency response. She highlighted Jordan's demeanor. No visible distress, no aggressive posture, just a man calmly communicating his rights. She showed the exact moment Daniels grabbed him. A sudden, unprovoked escalation. Then came the judge's piercing questions, directed squarely at Officer Daniels. "Did you see a weapon, Officer Daniels?" Judge Linden asked, her voice calm but firm. Daniels, squirming slightly in the witness box, mumbled, "No, Your Honor." The truth, finally. "Did Mr. McCrae threaten you in any way?" She pressed on, leaving no room for ambiguity. "No," Daniels admitted again, the word hanging heavy in the air. "Then on what basis?" Judge Linden concluded, her voice rising slightly. "Did you seize him?" Silence. A profound, deafening silence filled the courtroom. Daniels had no answer. There was no legal basis. There was only the assumption of a biased caller, the keep an eye note, and a history of unconstitutional stops. The city's flimsy argument evaporated under the weight of truth. The gavel banged, a decisive, resonant sound. Decision reserved. But everyone in that courtroom knew what it meant. The scales of justice were tilting. The verdict. 3 weeks later, the written opinion dropped. It wasn't just a legal document. It was a thunderclap of accountability, a meticulous dissection of injustice. Judge Linden's words were clear, unequivocal, and damning. The seizure of Mr. McCrae was objectively unreasonable. The opinion read, "This isn't legalese for a little bit wrong. It means completely, indefensibly wrong, without any legitimate legal justification." She further cited racial animus evidenced by contemporaneous notes, directly pointing to the new homeowner. Keep an eye entry as proof of discriminatory intent. The judge didn't mince words. Officers acted with reckless disregard for constitutional rights. This wasn't a mistake. It was a conscious, dangerous disregard for the very rights they swore to uphold. And then, the pronouncement that echoed through the city and beyond. Award to plaintiff, $100,000 plus attorney's fees. This wasn't just a number. It was a financial penalty designed to make the city feel the weight of its officers' actions, a tangible acknowledgement of the harm inflicted upon Jordan McCrae. But Judge Linden didn't stop there. She understood that simply paying out money wasn't enough to prevent future abuses. In a move that truly underscored her commitment to systemic change, she also ordered the police department to hold mandatory Fourth Amendment training, focusing specifically on probable cause, consent, and unlawful seizures. And to ensure this training wasn't just a rubber stamp exercise, it was to be overseen by an external monitor for 18 months. This wasn't just about punishing past wrongs. It was about safeguarding future rights. It was a proactive step towards real, lasting reform. Aftermath. The city, faced with such a damning and meticulously reasoned judgment, had no choice. Within 30 days, they cut the check. No appeal. No further legal maneuvering. The verdict stood, a testament to Jordan's courage and Keisha Williams's legal prowess. Jordan, a man who had fought for his country, then fought for his rights, took the first page of that written opinion, the one detailing the judge's powerful findings, and framed it. He hung it proudly next to his pool, a constant, tangible reminder of his victory, a symbol of resilience. It wasn't just a decoration, it was a declaration. As for Officer Daniels, the one who initiated the unlawful arrest, he eventually resigned from the Fayetteville Police Department. While a resignation might seem like a victory for accountability, the unfortunate reality of the system soon reared its head. He was later hired by a neighboring county. Yes, we'll certainly be keeping an eye on that situation, because the problem of officers simply moving from one jurisdiction to another after misconduct is a systemic flaw that needs urgent addressing. Jordan, ever the community-minded individual, didn't just pocket the money. He used part of the $100,000 to build a bigger, more inviting deck, transforming his backyard into an even more welcoming space. And right there, prominently displayed, he installed a welcome, no trespassing sign. A subtle, yet powerful statement. Welcome to those who respect boundaries and rights, but clear warning to those who would violate them. Beyond his own home, He funded swim lessons for neighborhood kids, ensuring that more children could safely enjoy the very space that had once been the scene of his trauma. His personal victory blossomed into a community benefit. Reflection. I had the chance to ask Jordan what the victory truly felt like. Was it the money? The vindication? He laughed, a genuine, hearty laugh that belied the trauma he'd endured. 100 stacks is nice, don't get me wrong, he admitted, a twinkle in his eye. It certainly helps. But the look on their faces when the judge said pay up, that was priceless. It wasn't about greed. It was about seeing those in power finally held accountable. It was about seeing justice, cold and irrefutable, delivered. Then his expression turned serious, the humor fading as he reflected on the deeper meaning of his fight. I fought for every other black man who gets told he doesn't belong in his own yard, he said, his voice quiet but firm. For every person who's been made to feel like their presence is a threat just because of the color of their skin. This wasn't just about my pool party. It was about proving that we have rights and we're not afraid to stand up for them. His words were a powerful reminder that sometimes personal battles echo with a much larger collective significance. If you're watching this and thinking that accountability videos like this one truly matter, if you believe that shining a light on police misconduct and the need for justice is important, then please hit that like button. It sends a clear signal to the algorithm that people actually care about these stories, about the payouts that hold authorities accountable. And hey, if you want more stories where the good guys, the everyday citizens fighting for their rights, actually win, then go ahead and subscribe. Join the community that believes in justice served. The broader picture. Jordan McRae's case isn't an isolated incident. It's a vital piece of a much larger puzzle. Let's zoom out for a moment and look at the bigger picture, because the numbers tell a story all their own. North Carolina, tragically, ranks 10th in the nation for police payout totals since 2015. We're talking a staggering $42 million and counting. That's $42 million of taxpayer money going to settle claims of misconduct, excessive force, and unlawful arrests. It's a heavy price to pay for a lack of accountability. When you break it down, the average settlement for unlawful arrest claims statewide hovers around $31,000. Now, consider Jordan's case. His $100,000 award isn't just a significant sum. It's the largest individual award for a no-injury wrongful arrest in Cumberland County history. Let that sink in. This wasn't about physical injury, but about the profound violation of rights, the emotional distress, and the sheer injustice of it all. What does this mean? In legal terms, it means precedent just leveled up. Jordan's case, with its clear findings of racial animus and reckless disregard for constitutional rights, sets a new benchmark. It sends a powerful message to police departments and municipalities across the state. The cost of violating citizens' rights, especially without physical injury, can be substantial. It empowers other victims and their attorneys, showing them that fighting for justice, even in seemingly minor cases, can yield significant results and force systemic change. It's a win that reverberates far beyond Jordan's backyard. What cops must learn? Jordan's case and Judge Linden's scathing opinion lay bare some fundamental truths that police officers and the institutions they represent simply must learn. These aren't suggestions. They are constitutional imperatives. First, probable cause isn't a hunch. It's not a feeling. It's not an assumption. And it's certainly not, I think one of them has a gun based on racial bias. Probable cause requires specific, articulable facts and circumstances that would lead a reasonable person to believe a crime has been committed or is about to be committed. It's a high bar for a reason. It protects our freedom from arbitrary government intrusion. The officers in Jordan's case didn't have it, and their actions proved it. Second, anonymous tips need corroboration. A hang-up call from an unidentified person, without any specific details or credible evidence, cannot be the sole basis for invading someone's private property and infringing on their rights. Police have a duty to investigate, to verify, to ensure that they are not acting on malice or misinformation. This is a bedrock principle of policing, and it was utterly ignored. And finally, the often used excuse, I fear for my safety. Doesn't work when you're the uninvited guest on private property, escalating a peaceful situation into a violent confrontation. Officers cannot manufacture their own exigency through their own unconstitutional actions. When Jordan was calmly asserting his rights, when he posed no threat, the officer's decision to use force was not about safety. It was about control and an unwillingness to respect a citizen's boundaries. The impact of Jordan's case is already being felt in unexpected ways. His story now appears in 2 different police academy case study manuals. And here's the poetic justice. Both of these manuals were written by civil rights attorneys, not by police department themselves. While we'd prefer police departments to proactively educate their own, we'll absolutely take the win. It means that future generations of officers, hopefully, will learn from Danielle's mistakes, not repeat them. Community impact. Beyond the courtroom and the legal precedent, Jordan McRae's fight had a profound, tangible impact right where it mattered most, in his own community. Before the party, many neighbors were cordial but distant, the typical suburban anonymity. Now something has shifted. Neighbors who never spoke before are now hosting joint barbecues, sharing stories, building genuine connections. The shared trauma and subsequent triumph forged an unexpected bond. Jordan himself, always thinking of others, installed a shared tool shed in his backyard, accessible to anyone on the block who needed a wrench or a hammer. On it, a sign proudly declares, "Community beats suspicion every time." It's a simple message, but a powerful one, reminding everyone that connection and mutual support are far more effective than fear and prejudice. Perhaps the most significant change, however, comes from the local NAACP chapter. They've reported a remarkable 22% drop in 911 calls for suspicious activity on that block. Why? Because neighbors now call each other first. Instead of immediately dialing emergency services based on a fleeting suspicion, they communicate, they check in, they build understanding. This isn't just a statistic, it's a cultural shift, a testament to the power of community organizing and the ripple effect of one man's stand. It's about building trust where suspicion once thrived. The unfinished business. While Jordan's victory was monumental, the fight for true, comprehensive justice is far from over. A stark reminder of the systemic challenges that persist is the fate of Officer Hicks, the second officer involved in Jordan's unlawful arrest. Despite his role in the incident, Officer Hicks remains on the force. Worse yet, he has been promoted to field training officer, now responsible for mentoring and shaping the next generation of police officers. It's a deeply troubling development, highlighting the uphill battle against internal systems that often protect their own, even in the face of clear misconduct. Jordan and Keisha Williams aren't backing down. They are actively pushing for a statewide registry of decertified cops. This crucial piece of legislation would prevent officers fired for misconduct from simply hopping to another department in a different county, continuing their problematic patterns. Unfortunately, like many vital reforms, this bill stalled in committee last legislative session. But they've vowed to keep lobbying, to keep fighting, to keep the pressure on. Keisha, ever vigilant, keeps Jordan's case file open, not because the case itself is ongoing, but as a symbol of promise. Just in case Daniel screws up again. Just in case Hicks continues his troubling trajectory. They are ready, because they understand that true justice isn't a one-time event, it's an ongoing commitment. From an unsuspecting pool party host to a precedent-setting civil rights champion, Jordan McRae proved beyond a shadow of a doubt that you can fight City Hall, and you can win. His story is a powerful counter-narrative to the pervasive message that often tells us to simply accept injustice. The next time someone tells you, just comply, remember this story. Remember Jordan McRae. Compliance, as his experience tragically illustrates, doesn't protect you when the system itself mislabels your very existence, your very presence, as probable cause for suspicion and aggression. It doesn't protect you when bias is baked into the initial response. Justice, in this instance, cost the city of Fayetteville $100 grand. That's a significant sum of financial reckoning. But the lesson, a profound and necessary lesson for law enforcement agencies across the nation, if they actually learn it. If they truly internalize the meaning of probable cause, accountability, and racial equity, that lesson could be utterly priceless. It could be the catalyst for real change, for a future where a peaceful pool party isn't a prelude to an unlawful arrest, but simply, wonderfully, a peaceful pool party. Drop your thoughts below. What would you do with the $100,000 wrongful arrest check? Would you invest, donate, or something else entirely? We want to hear from you. And don't forget to smash that subscribe button for more justice served cold. And please, share this with anyone who still thinks racial profiling is a myth. Let's keep these conversations going and push for a more just world.